Hello, everyone, and welcome to this week's scholarly talk. And we are going to have a discussion about the Supreme Court. And it's really fascinating because the Supreme Court has always been one of the branches that has been bold enough to make statements about our in ruling about civil rights issues. However, there are times where Congress has made some, statements. But if you look back in the history of civil rights movements across, for in regards to women, the women's movement, if you look across to issues when it comes to African Americans, if you look across when it comes to Latinos, if you look at a few cases when it came to the Japanese, um, the Supreme Court has been involved in all of these issues. And so, one of the pathways for all demographics of people of the minority group, whatever minority group has been existing in, they've always tried to go through Congress. They've always sought an ally within the presidency. And one of the big ticket, though, is to try to attempt to be involved with the Supreme Court. So, one of the issues that I think is really a surprising thing about all of this is that the Supreme Court has heard in the last, I would say, 3 years, two major cases in regards to LGBTQ rights. And let's put it on its face. First of all, LGBTQ rights has been a state by state issue. There have been a number of cases that have tried to go to the Supreme Court, and the Supreme Court has made a decision to not address it. One really cool case, which I would have loved to have seen to go to the Supreme Court, but it was rejected, was one in regards to Texas. It was a couple who got married in Connecticut, two lesbians, and they moved down to Texas, and their relationship no longer worked. They sought a divorce, and what ended up happening is so Texas denied giving them a divorce because they didn't recognize their marriage in the first place, and so they went to the Supreme Court, and the Supreme Court refused to hear it. Because for whatever reason, we never know why the Supreme Court refuses to hear cases. I mean, right now, on average, between 2 to 5% of every case that they hear. Of every case that they read, they only hear 2 to 5% of every case that comes before them. So it's a very rare thing when they actually get a case. That they actually hear a case. One interesting thing is that so when they heard a case in 2015, which in the state of California, a lot of people think that is very that is very liberal. State of California, it's liberal-ish. It's more purple. There are some parts of the state that is extremely red, like Orange County, and then there are some parts of the state that is extremely blue, like LA County. So it's really kind of depending on where you live. But anyway, there was a Marriage Equality Act that passed in 2008. LGBTQ individuals, different groups, thought of course, it would not pass because um, they had Obama who was on the ticket, and they thought that there's going to be so many liberals who are going to be voting, and it's going to be a landmark decision, uh, landslide to get Obama in, that they really didn't have to campaign. And what they discovered is that Hispanics and Blacks are overwhelmingly, especially at that time in 2008, even though they voted in high numbers in the state of California, they overwhelmingly voted in support of Marriage Equality Act, in which what it meant was it outlawed gay marriage. And so, the LGBTQ community was so outraged and didn't know where to kind of to take their anger, and so they protested in high numbers and around Orange County, and they also protested in Beverly Hills, but they should have came to the inner city because the inner city was heavily in support for the Marriage Equality Act. Anyway, since then, there was a lawsuit that was brought against them, and it went all the way to the Supreme Court. And in June 2015, at the time, Kamala Harris was our state attorney general, who made the decision not to go ahead and to defend the state of California's decision to outlaw gay marriage. And since she made that decision, because she was in support of LGBTQ rights, she made that decision, and so there were groups who actually helped fund the Marriage Equality Act, and they actually were the ones who went and supported um, and defended the fact that gay marriage should remain illegal because this is the will of the people. It was an interesting court case, and because that court case um, had some serious implications, because in California we have two things. We have uh, essentially almost like a democracy in the sense that anybody can um, propose a bill, and they can propose. Anybody can propose a bill as long as you fund it, and then they can vote on it, and it could become a constitutional amendment, or it can be, uh, or it could be just a proposition. So it was going to be added to the Constitution that marriage is going to be defined as between male and female. So the implications is that can if you can voters in the state of California or anywhere make the decision to vote for something, and then because it may violate a civil right of another group, can it also be vacated? Can that vote be then vacated without ever making another law to overturn that particular law, or having another constitutional amendment that overturns that constitutional amendment? Well, um, the Supreme Court didn't answer that, which is interesting. The Supreme Court didn't answer that question. But what the Supreme Court did, it answered the question by saying that there was no standing. So that group of individuals who supported, who was defending the decision to overturn, that defended the rights of the state of California to continue to keep this marriage act going that overturned gay marriage. The Supreme Court said that group had zero standing to actually defend and argue on the behalf of the state of California. So, why do I bring this up? Is because the Supreme Court now is doing two things. One, it's saying that the state of California cannot go ahead and appeal. The state of California cannot go and vacate a vote of the people. That's one. And two, it also is saying it's not making the statement that gay marriage it should be a constitutional right or not. And if you read the decision, it doesn't say that. It's only arguing based on the premise of saying that that this group doesn't have standing to come before the Supreme Court. So the question is, if Kamala Harris or someone arguing on the behalf of the state of California actually came before the Supreme Court and argued on the behalf of the state of California, then the Supreme Court would have to have found another way to address this question. The implications here is pretty clear. The Supreme Court is not willing to make a centralized stance on if gay marriage is a constitutional right or not. And there was another time that the Supreme Court could have made a decision, because this week, in the week of the first week of June, the Supreme Court handed down a decision against a baker. There was a baker in the state of Colorado who a gay couple came up to them and asked if they could bake a cake. And Colorado, this Colorado bakery said, no, I'm not baking a cake because I do not believe in gay marriage because it violates my constitutional right against religion, my religious principles, and so it violates my First Amendment right, and I do not want to bake the cake based on my religious principles. Okay, so it went before the Colorado Civil Rights Commission, and LGBTQ is a protected class within this country, and so therefore this Colorado Civil Rights Commission said, you know what, you're violated your religious freedom does not supersede somebody else's civil rights, and so therefore you can't say that you can't bake a cake based on your religious principles, which is fair. Okay, so now we have the Supreme Court who heard the case and said, okay, Civil Rights Commission, you went about this procedurally wrong. So again, it overturned the bakery. So again, we are back to the Supreme Court unwilling to make a statement about LGBTQ being able to marry as a constitutional right. We can argue, and there's actually what's interesting is there's arguments saying that there's some positives in this for both sides. So the religious groups are excited about this decision. The LGBTQ groups are, of course, disappointed, but there's an argument saying that they shouldn't be that disappointed because because for the first time we do have some language from Justice Kennedy saying that LGBTQ individuals do have a right to actually marry, but we're looking at the procedural and how the commission went about evaluating this case, and they did not go about the evaluation of this case according to what is legally bound by the commission. So that's fair, but what are the implications now? Are the implications then that people can discriminate against LGBTQ people based on religious principles? And the answer is no. This case does not say that either. It does not support the religious freedom to discriminate. What it does is that the commission, this particular commission, and whatever commissions are out there, they have to do things procedurally accurate. So there is no win for either the religious side or the LGBTQ side, but what it is saying one distinct thing is that the Supreme Court as of 2018 is still not willing to say confidently that LGBTQ individuals have an absolute right to marry. And it may be that we may never, it may be that the Supreme Court, maybe it's not in their place to say it. Maybe the Supreme Court is saying, this is not where we want to go. If you want to absolutely have this right, then you need to go to Congress. And, clearly Congress is not going to do this. So, I don't know where you're going to go there. But it leads us to some further implications, and I look forward to some of your other discussions if anybody wants to discuss in the comments. But it does lead to the question, which is a very simple question. Is the court system the place that helps give equal rights to marginalized populations? Well, thank you for joining us this evening, and have a great rest of the week.